You're listening to State of Arrest with criminal defense attorneys William R. Moore and Drew Atria. Okay, Drew, so much of what we do as criminal defense attorneys revolves around being a great orator, to get an idea to stick. We recently did a show on different methods of getting ideas to stick, selling your case to a jury, getting people to listen to you, and explaining your case in such a way that doesn't just make sense, but gets through to the individuals that you've learned about in jury selection, right? Always jury selection, where everything starts. But jury selection is also an excellent time to learn about how your jurors learn based on the three primary learning principles, correct?
Correct.
All right.
The three primary principles. By the time the defense gets up, they've listened to the judge ask questions and the responses, as well as the prosecutor. So you probably got about 40 minutes, maybe more, maybe less, of listening to their language. Now, beyond listening to their language, there's other ways to determine. The three primary ways are sight, sound, or feeling.
Now, when you say feeling, touch.
Touch.
So we're not going to explain a case through touch because no court in the country is going to allow us to do that. But we're going to use words.
Feeling. When you say feeling, it's not just it is touch, but it's also feelings, emotions. In other words, people who are make their decisions based on their gut are feeling people. They're what's called kinesthetic people, kinesthetic learners. So you reach them by talking to them about the feelings your client perhaps had during the case. Maybe he was panicked, maybe he was scared, maybe he was being attacked and he had no other choice but to fight back or defend himself.
Is that a good way to identify a more sympathetic or empathetic juror? Somebody that's more prone to buy an argument for sympathy that's covertly established for your client, or if your client's victimized or treated unfairly by the police? Sure it
is. And particularly if they're what you would consider to be your leader. What I found is, after doing about, 400 trials, and I would always try to guess who the leaders were until I learned, and I said to myself, why don't I just ask them? How many people here think they're leaders?
That's the way to do it, isn't it?
Well, first of all, think about this. Since you have their attention for a few moments, the first words you say have got to grab them.
To get them to bond with you, to like you, to...
Well, first of all, before you bond with them, you want to tell them what this case is about. Let's say it's a case, your case, no matter how it ended, someone got injured, maybe they got shot, maybe they got even killed. But it was what you felt from your client telling you. He had no choice. He had to defend himself. So the first thing you get up and say might be, this is a case of self-defense.
Got it.
Now,
you mean you're almost what you're allowed to do in terms of pre-trying, because they've already heard what type of case it is, what the case is about, but you're going to give them an idea of what the defense is, or they're not shutting you out and growling at your client. They know you've got something to say.
You're legally entitled to ask the biases and prejudices of the jurors to your defense.
So when it comes to the three methods of learning, we got the auditory, right,
Mm-hmm.
the visual, and then touch. Touch is basically you're going to relate to those jurors by using specific words and possibly even sympathy, how people felt, how people were treated, potentially.
Mm-hmm.
Orating is already covered because it's the whole case. That's what you do as a criminal defense attorney. That's what you do as a prosecutor. That's what anybody does in criminal law.
That's right.
And in trial work in general. So you got that covered. But the visual, I think the visual is so important. I can't emphasize it enough. There are a lot of attorneys that will claim, well, the case doesn't call for an exhibit. Well, I can't remember the last time I went to trial without some form of exhibit. At the very least, we have an exhibit printer, so we don't have to rely on our vendor anymore. At the very least, from a criminal defense standpoint, you want to blow up weighing the weighing the evidence. Right? The prosecutor will blow up the elements. Maybe you too, if you're going to tear one apart. So it's even better is to comment on the states if they happen. But weighing the evidence, reasonable doubt can come from conflicts in the evidence, lack of the evidence, or the evidence itself. When you have that blown up real big, and they see that, they remember it when they go back, and they read it on the jury instructions, that sea of jury instruction. I can't emphasize an exhibit. It's kind of two-pronged though, right? It's visual, but you're looking at our words. But that's still visual learning, correct?
Correct.
Okay, so that works.
Because visuals will picture in their head the words
Got
that
it.
you use. For example, the easy way to spot a visual person or auditory or feeling person is you look at their eyes. Now, well, listen to this. If you watch which way their eye movements are, if they look up to the right when they're talking, it'll look to your left. They're thinking of something that they have never seen before.
And it's that easy? It's that dead of a giveaway?
Oh,
Really?
yeah. Oh, yeah.
No
Now,
kidding.
and so if you can pick up these things as the eye movements as well as the words. If they look up to the left, they're remembering something they've seen. So if I'm talking to you and I ask you a question that deals with my defense, and you've seen that before, let's say self-defense, you've had to defend yourself or your family or friends, or you've seen a movie, you're going to look up to the left.
Okay.
And now I know,
Some
I
experience in
gotcha.
there.
This is something you've seen. You're going to use that experience to make your decision, and I'm going to try to tie it in by getting you to talk about that experience so that I can see if it meets or melds with the defense version of what happened.
But only so much, right? You elicit too much and it's too good of a juror. The
No.
state's going to bounce them.
What I'm saying is all I want to do with them is bond,
Got it.
but I want to know how to bond with them, and then when they sit, I'm going to use that on opening.
Got it.
Okay, now, auditory people. This is easy. When you're asking them
Okay, sorry.
questions, they're looking.
How to identify them, you mean?
Yeah, how to identify them. The people who hear, they'll look from left to right. They'll look to their ears, because when they do that, if they look left, always remember, left is remembering something they've heard. So if I would, and watch, when you see these commentators asking people on TV about situations, whether they're congressmen or whatever, watch their eyes. If you see them look to the left, which to us would look to the right, watch, they're remembering something. They call it constructing if you look to the right, okay?
Constructing, and is that when they say you can
That's
tell
a-
if somebody's lying
Yeah.
and all that baloney?
Lying or making it up. They haven't seen it
Right.
before, but they're
I hate
so
that.
auditory people they either heard what you're talking about before or they haven't.
Right.
Okay? So you watch their eyes. If they look up to the right, they've never seen it, the visual people. Up left, they've seen it before. The auditories left, they're remembering something they've heard. Right to their ears, they haven't seen it before. And now listen to this one. If they look down left, they're talking to themselves. If they look down right, they're accessing their feelings.
Got it.
So that's one easy way to
I
tell.
can use a
about it.
refresher course, but I get the idea.
Yeah.
Up and to the right, constructing. Almost haven't heard anything before. Also,
No,
haven't heard
upright.
it before.
Watch their eyes. Let me see. What do we have here? We're talking visual, right? Upright. Never seen. You're right.
Ever seen? So somebody says, your wife says, "Hey, I don't think you were at the baseball game last week." You don't know what she's talking about. You look up to the right, and then you're looking up to the right. You're lying.
And
See,
the-
it's just a
Well, they got a
Tell me.
suspicion if they know
Yeah,
about it. You don't
right.
want to teach them.
right. It's almost like a case, right? You want to know what they know before. I mean, of course,
Yeah.
no one's a cheater here, but it's funny when
No.
talking about this stuff. I swear I get a kick out of it.
And the thing about people who feel, if you watch their eyes down right, when they look down right, they're accessing feelings. So you're just looking down left.
So, in identifying these things, ultimately, I mean, you've got orating down. That's what you do. If you use exhibits, which you have to, and introduce as much stuff into evidence as you can that even mildly helps your case, or even just at a bare minimal, so you can show the jurors stuff, and you can have the things introduced evidence. They take it back into the jury room with them, and they just love playing around with it, and they're thinking about you, and they're thinking about your case, right? And when I first started with exhibits 20 years ago, actually before 2000s, before late 90s, I was going against a great prosecutor, he's great trial attorney, Jonathan Green, and we were going head to head. It was like our third case together, trial. I was a PD. Boy, oh boy, I'm surprised I didn't go fisticuffs in the courtroom. But I had a candle that the client had brought in before trial that had really nothing to do with the case other than the fact that it was lit by her on the beach when the police showed up. police officer mentioned it, and on cross I go to pull this candle out that hasn't been pre-marked, hasn't been shown to the state, anything like that. We're already, you can't stand each other, right? Here's the sound effects, right? And actually a real train, beep, beep, it's a locomotive. But I went to pull this candle out, and Jonathan saw me about to pull out a piece of evidence. He didn't know what it was, 'cause the tables are blocked all the way around. He went crazy objecting. Come to find, get the not guilty verdict, and the jury was they were irritated that he wanted to stop me and did stop me from showing them something that had to do with the case, right? And he's better than that. He was just so mad at me because of the way our trials have been going. I guess I was a little bit sneaky back then, but that's an example of how important visuals are, how much people want to see it, and I think they all wanted to at that level. But you had told me, and don't mean to get off topic, but you had told me that I think I had said, well, the dominant, the heavier weight of the group are those that learn visually, but that's not true.
Actually, visual people, they can compose 40 to 55% of the population, and interestingly enough, auditory people who rely on hearing, it's 15 to 20%, and feeling is 30 to 40.
Okay, so it is the highest, but not as high as we would think in comparison to auditory.
No.
Wow. So that's why.
Well, you know what? Maybe the reason we can only retain so much when we hear it. That's why telephone numbers have 7 digits.
Right.
And we block out all the rest. Think about it. You go to a restaurant, a fancy restaurant, where the waiter tells you about 5 different entrees with different vegetables, different salads, and the this and the that, and they put the sauce, and then they do this, and then they do that, and what do? I usually go like this. Oh, okay, thank you, because I'm thinking, geez, that one's, which I can't remember which one sounded better, so I say thanks, and I read the menu.
But at the old Burton Jack's, when the Port Authority shut that restaurant down because you couldn't get to them anymore, or at Jackson's, they also shut down great restaurants, they'd bring the lobsters and the steaks out so you could see them, didn't they? Mm-hmm. And they brought versions of the entrees and the desserts out on a platter, on a cart, so you could see them.
Yep.
That was fun.
See, that's exactly right. And so, first things to determine which is their preference is to look at their eyes, then listen to their language, and then make a decision after you find a base, watching them for a while to see whether they're auditory or whatever. Like when we're talking now, you're looking down. So what I'm thinking is you're talking to yourself. You're either accessing feelings or having this constant discussion.
Looking at my notes that I've been writing down as we've been talking.
Oh, okay. But if that would be the way I would read it.
Right.
And I practiced by watching
Maybe
TV.
I was.
Do you know what I mean?
Yeah.
Yeah, because it didn't look like you were reading. It didn't look like you were reading. It looked like you were more absorbing the way we input information.
Just a good show. No, in all seriousness, it is. Yeah. I mean, you got me. I don't even remember what I was. I probably was.
See,
so what does that mean?
That you're talking to yourself? Well, if you're talking to yourself, first, if you're accessing feelings, if I'm talking to you and I'm trying to reach your feelings and I see that you're looking down, let me see which one the other, or feeling people, they look down to their...
Oh, no, I'm a feeling person.
No. What that means is that I know I got your feelings.
Ah, you know what?
And
True.
I can push on it. I can expand on it.
I think that's what I was doing. I think I was talking to myself. Probably thinking about what I wanted to say next. That's bad.
Well, you see, here's the thing. And think about how instantaneous these things are. I picked all that up while I was talking to you.
Yeah,
and I modified what I was saying. Once we get this, it's like a new
deep
skill. Well, but think about it. Babies can't even pick up their heads at first. They can't even pick up their heads to turn over. Forget about walking and running.
Right.
If you ever had a little child. What I'm talking about is it takes time to learn this. Do one at a time. Learn the auditory, learn the visual, learn the different ones, and watch them. Watch TV.
I bet if you've got your foreperson pegged and you know the
you
best
don't have
way
to have them
communicate.
pegged. He's handed it. He's put his hand up.
Right. If you got them, I mean, I love picking the foreperson ahead of time and guessing it. And you can pretty much get it over 90% of the time. But you can curb your presentation of your case completely because that's your soldier, that's your leader, and that's going to be your voice back there in the jury room. Drew, we're out of time. Thanks again.
Thank you.
Had a great time. Thanks
I
for
did too.
sharing your knowledge.
Thank you.
Until next time. You've been listening to State of Arrest with criminal defense attorneys William R. Moore and Drew Atria. Be sure to tune in next week.